Good morning. It's good to see you all. We've had a great meeting so far, and I expect that to continue, especially with our next speaker. Mr. Mark Baker is a representative, state representative from Rankin County. He's served in the House of Representatives since 2004, and he has just Rankin County and he had part of Madison County, so I've known Mark and worked with him for a long time, and worked with him on various things, including some bail stuff too. He's been a Republican leader in the House from one term, 2008 to 2012, and he helped coordinate the Republican takeover, the creation of the Republican majority in the House for the first time since Reconstruction days. He is the chairman of the House Judiciary A Committee and the combination of the Judiciary A and B, the Judiciary and Bank Committee. He's a member of several other committees there. He's been endorsed by a lot of conservative groups such as Mississippi Right to Life and the National Rifle Association, and has received very favorable ratings from a lot of conservative political organizations. He's been a member of the Mississippi Bar since 1987 and is engaged in private practice. He's admitted to practice law in all the federal and state courts in Mississippi and the United States Court of Appeals for the Fifth Circuit and the U.S. Supreme Court. He's had a lot of trial experience as a prosecutor and a judge, I think municipal judge in Brandon. He's also a licensed property and casualty insurance agent, former member of the Rankin County Republican Executive Committee, and past president of the Rankin County Bar Association and the Rankin County Rotary Club. He graduated from the University of Memphis in 1984 and Mississippi College Law School with distinction in 1987. And I'm not going to give you his age. He's married to a really sweet lady named Lady Collins, has one son named Chase, who is currently at the Trent Lott Leadership Institute at Ole Miss, and they are members of the Presbyterian Church. So I give you my good friend, Representative Mark Baker.
I come in the room, I'm not here 5 minutes, and Chief Companion starts talking about lawyer jokes. So let me tell you a story about that. There's actually only 2 actual lawyer jokes. That's right. The rest of them are true stories. Anyway, thank you, Al. Appreciate that introduction. Robert, Gene, good to see friends in the audience. Al mentioned my wife, Lady. On July 1st, we were married 29 years. I never get in trouble with regard to remembering anniversaries or birthdays because she always remembers them for me. Puts them on a piece of paper and tells me what I need to get for that particular year. And it always works out. Reminds me of a story of a husband and wife that had been married for 60 years. They were getting in failing health. They were trying to get their affairs in order. And when they got married, the wife put a shoebox up at the top of the closet. She told the husband, she said, "Don't ever ask me about it. We don't ever want to talk about it." So after they'd been married about 60 years, the husband decided it was time to get affairs in order. He brought the shoebox to the wife. He said, "I know you told me never to ask you about it. I know you told me you never want to talk about it. But I think, something we probably need to talk about." She goes, "Okay. Go ahead and open the box." He opened the box, and there were 2 little crochet dolls and $10,000 in cash. I said, "What's this all about?" She goes, "Well, when we were first married, my grandmother told me," she said, "that the key to a successful marriage is to never get into a fight, never have an argument with your husband. If you ever get mad, just go off and crochet a little doll." Oh, the husband got all well. He thought to himself, 60 years of marriage and got the 2 little dolls in his box. My goodness. He said, "Well, honey, that explains the dolls. What about the cash?" She said, "Well, that's the money I made selling the dolls." So now and then in life, we find ourselves in positions that we didn't create, right? You get a call from a client, they've got a problem, you've got to address it. Law business, I'm that way. It happens in life as well. You guys are sitting around minding your business, responding to calls from the court, coming to court, issuing bonds set by other people, maintaining your business, keeping your certifications, keeping your qualifications, and just living life and doing the job that you do in the best way that you can. And now you're sitting on a three-legged stool that you didn't ask to be placed there for the results of your profession. And one leg of that stool has been propped up by decisions made in the courts. One leg of that stool was propped up by decisions and bills that were passed in the legislature. And one leg of that stool was propped up by the recent court rules that were passed by the Supreme Court. And here you find yourself sitting on top of the stool. So the question is how do we get you off the stool and back to work so you can maintain your profession and provide the service to the community that you have provided without fail for all these many years? Well, let me start off by telling you that as the chairman of the Judiciary Aid Committee, I did not vote for House Bill 585. I thought it was a bad bill. I thought it would lead to where we are today. My district attorney, Michael Guest, who's now the Republican nominee for Congress, and my sheriff, Brian Bailey, from Rankin County, called me up and said, look, this is a bad road to go. We've got a problem here. Before I got elected to the legislature, I prosecuted in Brandon for about 10 years, and so I interacted with your profession, many of you that practice up in that area, on a weekly basis. And during that time, I was also the judge in Biloxi. And so I worked with you on that, in that capacity. And candidly, I never had a question or a concern or an issue, because when a defendant was out on bond, I knew that the defendant would be in court when the defendant was supposed to be in court. One of the other things that I do in life is I'm the city attorney for the city of Brandon, and I'm the town attorney for the town of Puckett. Does that have anything to do with what you're talking about today? Well, I'll tell you, because I'm intimately involved in the process of budgets, in the process of personnel, in the process of knowing how much it costs to run the railroad, so to speak. I've been the board attorney in Brandon since 1992 and the town attorney in Puckett since 2003. So I know, back to the railroad analogy, that a train wreck has happened. And so the question is how do we help law enforcement? How do we help the courts? And how do we help the city? And how do we help the greater good in society? The question was asked earlier of the chief, what is the net effect of the no-shows? What is the net effect on budgets? They don't know yet. But we know, right? I mean, we know. We know people aren't showing up for court. We know that the manpower that was used to prosecute, to arrest and prosecute and convict is the manpower that exists. There is no more. If the chief were to be asked today if his officers needed raises for the work that they do, he would tell you absolutely. If he could, he would. If you ask the mayor and board in Gulfport or Brandon or any other city in this state whether or not the people that work for their municipalities work for their court systems, their police departments, whether or not they're doing the best job they can and whether or not they need more money, they would tell you they could, and they do, and they absolutely should. And so now we're faced with a situation where, in addition to arresting the bad guys, in addition to prosecuting the bad guys, now we've got to spend an inordinate amount of time finding the bad guys. And I've got to tell you, for me, that's a problem. So what do we do? Well, it's like eating an elephant. You're going to have to eat it one bite at a time. And so the first thing that we need to do is we need to stop the private settlements that are occurring with regard to municipalities throughout this state. these settlements, one with Moss Point, one with the city of Jackson, are terrible. And they are being represented to the rest of the state as if this was a determination by the court, a ruling of the court, so to speak. That this was the opinion of the court. Well, it doesn't take an attorney practicing law for 30 years to know it's not the opinion of the court. It was a settlement by the parties that was presented to the judge as a settlement of a lawsuit. And the judge said, okay, you guys have agreed, huh? Okay, fine. Give me the order. Sign the order and we're done. So, unfortunately, what happens in the municipal arena is that when a lawsuit like that is filed and then settled, at meetings like this with mayors and aldermen and police chief, prosecutors and judges, suddenly these settlements become, well, this is probably how you should do it. Not going to tell you you have to do it, but this is the way you probably should do it. And oh, by the way, if you're a member of the municipal association and you're insured by us and you don't do it, then we kind of have issues as to whether or not when you get sued, how you're going to be protected for not doing it. So you see the problem. So the first thing is these settlements have to stop. And how do we do that? I have, next session will be my 16th and final session in the Mississippi legislature. I sat down and started counting and said 4 terms is enough. I'm going to tell you a little bit about my plans in the future after a bit, but one of the things that I think is necessary is, and I've asked the legislative drafting office to prepare this legislation, would say quite simply that a municipality or county or any other governmental entity having been sued where the claim alleged is a constitutional violation or a contention of constitutionality which will have a statewide impact, that no settlement can occur without the intervention or the opportunity to intervene by the Office of the Attorney General. Why? And it doesn't have anything to do with the fact that I am in fact running for Attorney General in 2019. It's good policy, and let me tell you why. The lawsuit, because you don't know the private motivations of the mayor and the board going forward. And so, if you have a mayor and board in a small city who feels aggrieved and has an internal conflict with the police department, not saying that's ever happened before, and you find that the police department, or you find that in a small town in Mississippi, the police department took it upon themselves to arrest a bad guy for doing bad things, and unfortunately the bad guy was somehow related to some of the good guys that didn't want the police department to arrest the bad guy for doing bad things, suddenly you find yourself with competing interests in lawsuits. And those competing interests need to be resolved on a statewide level so that when settlements are implemented, if they're implemented, there is a public policy beneficial interest analysis that occurs statewide. And you may have, I don't know how closely you are following the cases that are out there, but in fact, when you look at the Harris County case out of Texas, and you look at the Fifth Circuit case kind of reporting on that, what you find is that when an attorney general intervenes in the lawsuit and becomes active and proactive in that lawsuit, what you find is that the resolution of issues become much more clear, much more precise, and much more workable, and much more reasonable. I think that unfortunately, and look, I don't know everybody's lot in life, but I know that if you commit the crime, you need to do the time. And so I know that there's this hierarchy of analysis going on that says, well, we're going to look at indigency as a defense almost to the crime that you committed, not only for bond purposes, but for post-conviction fine purposes. I disagree with that. And so we've got to work toward these lawsuits to make sure that we back these lawsuits and these settlements up. And I do believe that the Attorney General should intervene and stop these. For example, I'm sure all of y'all have read these cases, the Bell versus City of Jackson case, the Mossboard case. I'm sure you've read them. But did you notice that within these cases, they try to infuse factors within these settlement agreements? They're very broad in language and almost to the point, well, not almost to the point, but actually to the point of setting up economic analyses with regard to the process. Well, I disagree with most everything I read in the City of Jackson case. When I looked at the process of that case and looked at it as to the impact with regard to the court system and with regard to the beneficial intent, I disagree with all of that. And so something should happen there. The other problem that we have is that your association is very proactive in the legislature. Let me commend your lobbyists and your representatives for coming to the legislature. They work very hard on your behalf, and they're going to continue. And obviously, the next session is going to be critical, and we're going to move forward on some things to try to make your profession sound and viable, to maintain your profession as being sound and viable. And so one of the things that we have to do from a legislative standpoint is, and you hate to do it, is we have to determine whether or not the rules as adopted by the Supreme Court, the criminal rules of practice, whether or not we, the legislature, need to scale that back. Now that creates a lot of entanglements. Anytime that you start looking at the actions of one branch of government and the other branch of government, the separation of powers issues. But we have to. Created within the criminal rules is the most unique, obstructive, problematic mechanism that I've read in a long time. And it is this unsecured appearance bond that we heretofore had not had in Mississippi practice except in federal court. I would submit to you that the federal court is a lot different than the municipal court of Tennessee. Okay? And they have the wherewithal and the means whereby to provide for the post-release follow-up that's necessary when you have a system like the unsecured bond system. And so we've got to look at this very closely and see why this exists and how this would best apply to governmental entities and defendants in the state of Mississippi. I have some other issues with regard to the language of these rules, particularly 8.2 that talks about this pre-firing that the court must make charges filed pending determines that such release will not reasonably assure the defendant's appearance as required. So before you can even get to the question of not doing an OR or an appearance bond, you got to get this, and you know this. But understand that it's a question of making sure the defendant appears in court, yet at the same time in the analysis we're to consider the defendant's financial condition. I don't see in a relationship with one's financial condition as to appearing in court. You're either going to come or you're not. And so I think that we have to spend some time and see whether or not there are some opportunities to tweak some of these rules indirectly or directly through the legislative process. And the third thing is quite candidly, I believe that the legislature needs to listen more, and I'm in the legislature, so I'm talking about myself as well. The legislature needs to listen more to those that know, okay? And to understand that municipal judges and municipal prosecutors and those in your profession, county judges and county prosecutors, justice court clerks, know the system, and they know what's going on, And nobody's trying to get over on anybody. We're just trying to make sure that the sausage gets made. John Doe's arrested. John Doe is processed. John Doe comes to court. John Doe gets his day in court. Whatever happens then, we move forward. That's all we're trying to do. And so we need to go back from a legislative standpoint. You know, I told everybody when we pass 585, we'd spend the next 10 years just putting it back the way it was. And pretty much it's kind of happened. We passed it, and then the first year there were 16, 18 different changes. And I'm exaggerating, but there were many changes. And then every year since that, there have been changes. And every year since those changes, tucked in those changes, have been problems. Because in attempting to change it back and working through what was then a 400-page document, you create unintended consequences yet again. And so I've asked the speaker that when next session, when these bills come through the House, that they can come to the Judd A committee. They historically went through the Judd B committee. Our Judd B chair, Andy Gibson, was appointed by Governor Bryant to be the agricultural commissioner. So there'll be a new Judd B commissioner. So I'm hopeful that bills that affect your profession, bills that affect the administration of justice through the municipal and justice courts, actually proceed through Judd A this year. And, you know, I would say you have a friend in me, but in reality, you have a prosecutor and a judge and a city attorney and a legislator, which by default means that you guys are critical, and what you do is critical to ensuring the success. And when I say success, I just mean the process being completed in a timely and efficient manner. This idea that we're going to release people basically, essentially, before the paperwork's done, as the chief mentioned, and then spend our time trying to find them, and then apologize to them for having found them, and then bring them forward and give them another opportunity to come forward and appear, and then not appear, and then apologize to them again, and then at that time do an analysis as to whether or not they're in contempt, and if in fact they're in contempt, put them in court. No, by the way, the combination of contempt cannot exceed the fine and the cost that was originally done to let them serve in jail, and it's getting to be where it's going to be about a year out, and I would say in about another year, when budget time comes through again for the cities, this thing is really going to come full force in effect. And the pendulum, Chief's correct, it has swung way up here, and it's going to slam back pretty quick, but we need to help bring it back, and we need to help bring it back quickly. I know it's lunchtime, and I'm going to kind of quit. I'm going to take some questions from anybody that may have questions. Yes, sir.
First of all, it was refreshing to hear you speak this way. Since I've been talking the way you're talking right now for a few years, and a lot of people don't understand the criminal justice system. It's a beast. It's very large and comprehensive. And the general public doesn't understand how it all works and fits together. But the other question I was going to ask you is, are you aware of the MacArthur Law Clinic that's going on at Ole Miss?
I am.
Well, you were talking about how to stop these lawsuits.
Right.
And so I was just making sure that you were
Well, and the MacArthur Law Clinic, y'all know who they are, right?
Yeah.
And they're like, they are Mississippi's, I guess now, for lack of, well, this is going to be my term. I'm not going to say for lack of a better term. I can come up with a better term, right? They're our Southern Poverty Law Center. They're our, whatever you want to talk about, type situation, organization that is working hard for the downtrodden and the oppressed. Now, I'm not trying to make light of that. I'm just trying to tell you that the downtrodden and the oppressed commit crimes, and they need to be treated the same way as everybody else when it comes to committing crimes and moving the process along. The MacArthur Institute they've got a little wind at their sails, okay? And so they picked off some municipalities that were conducive to settlement. And it goes back to this concept that, no, wait a minute, because they didn't even fight. if you look at these lawsuits, they were pending forever. It wasn't like 15 years of vigorous litigation and almost bankrupting the city later. It was basically file a lawsuit in relatively short time, do the settlement. Well, that city made an economic decision. We don't want to mess with it. We don't want to do whatever. I'm going to take that off the table for them and say, look, don't worry about it. I got this. 30 years of law experience, 30 years of courtroom, city attorney, prosecutor, judge, legislator. I can figure it out. Y'all sit on the sidelines and I'll litigate with them. But yeah, I've heard about them. They're moving in a lot of areas. And they do good work in some cases. There's a current lawsuit pending with regard to some youth court matters in another city in the state, and one would argue that something needs to be addressed in that regard. But with regard to this issue, it's just gone. I mean, here's my thing. If you read the City of Jackson settlement and you read this agreement, I bet you nickel, they're not near in compliance with this thing. It's like a Rube Goldberg cartoon. You got to do this and jump over here and do this and do this and do this. And you know, I'm sure they have great people at the municipal court system there, but keeping up with this, impossible. Yes, sir.
Well, get back to the McCarthy deal. What they'll do is they'll go in and sue that city or that county on the youth deal, and they'll stick no bail in there as a settlement.
Well, and it's highly likely that they do that. I can tell you that those that are involved in that city are looking for that and are working to it, because candidly, I don't think the city is, I think the city liability issue is negligible at all. There were other issues involved there. But you're right, and it goes back to, and I wish I had the language in my bill, but it goes back to this idea that when there's an impact, constitutional impact, constitutional question involved, the Attorney General's office needs to at least have had the opportunity to intervene in that lawsuit prior to settlement at a point in time where they could vigorously defend it and represent the interests of the state.
Does the current law forbid the Attorney General from intervening?
No, it doesn't forbid it, but I figure sometimes you need to be proactive and put it in law and say you forbid it.
So he could have intervened?
Yes.
Okay.
Now, candidly, I mean, did he know? I mean, the lawsuit, I don't have the docket sheet on Moss Point, but was there time? I mean, was it filed?
It wasn't long at all.
Yeah, so I'm not being critical of the office for that. I'm simply saying that, you know, we've learned that this has got to be resolved in a different way, and we've learned that we need a more global perspective and a more broader public policy interest review when it comes to these issues. Yes, sir.
Representative Baker, can I go back? Well, let me say this. With these cases and the Supreme Court and the rules, I'm speaking of the judge, and basically now are handcuffed ourselves. And my question, can I go back to my conference and tell them that help is on the way?
I wish you would. And look, and I know, because I've had conversations with a lot of municipal and justice court judges, and you're sitting here going, okay, I got 48 hours, right? No more exclusive of holidays and weekends or whatever it is. I've got to go through this analysis. There's actually some problematic language in 387, post-conviction language that actually appears in the Jackson case pre-conviction about the means test, indigency, and what city?
Harrison County Justice Court.
Harrison County Justice Court. And so yes, I wish you would, and I'm going to meet with the lobbyists for the municipal court judges and the justice court judges. I know you guys are in transition on lobbyists, so they're in transition on lobbyists. I get 10% by that. And we got to work on this, and we've got to work together. Now, I will tell you, is the camera still on?
Going off?
Yeah. And I've I'll give you my card before I leave, and you can have your guys talk. Okay. Back on the record. Thank you. Appreciate you having me. I'm going to stick around for just a few minutes. If you have some questions privately you'd like to ask me about, please do, and I'll be glad to talk to you about it. Thank you so much.